So now we wrap up our discussion on fair housing laws. And the next thing you see here, it talks about avoiding discriminatory buzzwords. Again, HUD thinks there are some what they consider buzzwords that could be considered discriminatory. Things like ideal for young couples or perfect for families can seem discriminatory towards elderly or single applicants. Using words like safe or limited or exclusive might imply that you have control to whom you rent. And these would be considered violations by HUD. So, you got to be careful with the verbiage used when you're marketing or advertising. This next bullet here, says putting up an ad for a community Christmas party or displaying images of Santa does not violate the act, but advertising for a Christian roommate within the community's common area does. That seems like a stretch for me, but that's what HUD says. So for test purposes, that's what you need to know. Apparently you cannot advertise for a Christian roommate. So, I'm going to leave that one alone. And then, there are some exemptions to fair housing laws, and you need to be familiar with what these are. Obviously, so for those that fall under or meet one of these exempt criteria would be exempt from fair housing laws. Now let me be clear. Real estate agents are not exempt under any circumstances. So even if you meet or fall into one of these categories we're getting ready to talk about, if you have a real estate license, you're not exempt. So just keep that in mind. But the first exemption says anyone renting or selling property by owner. Obviously, if you're selling your house or renting property by owner, now again, if you hire an agent, you no longer are exempt. The real estate agents are not exempt, so just beware of that. But a good example, I think, what they're talking about there. Let's say you have a female owns a house, say it's a 3-bedroom house. She lives there by herself and decides she wants to rent out one of the rooms. Obviously she's looking for a roommate. Very common with a lot of people to try to offset some of the expenses. Well, she might decide that if she is going to look for a roommate, she only wants a female roommate. She doesn't want any males living in the house with her. Well, obviously, that would be discrimination. So what protected class would she be discriminating against? Sex. That's a protected class. But because she owns the property, she actually lives in this property, then she would be exempt, and now she can discriminate against sex and declare that I'm only going to rent to females. Now, what you need to be cautious of here, what she could not do is advertise in a discriminatory manner. Now, that would be a no-no. Nowhere she can't put an ad in some magazine or anywhere for that matter, social media, whatever, advertising for a roommate and then put females only. That would be a violation. You can never advertise in a discriminatory manner. I remember that. So basically, she would just have to put some ad out there that she's looking for a roommate, and if a male just happens to contact her about wanting to rent, then she could just go ahead and tell him that she's only looking for females and will not accept any males. She can do that, but she cannot advertise in a discriminatory manner. Religious organizations are exempt. Churches. A lot of churches, just for example, they will have like a parsonage or something, a house. A lot of times, typically, would be occupied by the preacher or pastor or whoever. But maybe you have a situation where the pastor says, well, I already have a house, and I don't want to move into the church-owned house. I'll just stay in my house. Well, in cases like that, a lot of times the church will just rent the house out. Well, maybe y'all say it's a Baptist church. They might decide, well, we're only going to rent to Baptist. Well, obviously that's discriminating against religion. But religious organizations are exempt. Now, what they could not discriminate against is who could become a Baptist. So, if you got a tenant and they're saying, well, I'm Baptist, then obviously I think they have to go ahead and rent to them. Private clubs are exempt. If it's a private club and you're not a member of that club, then you're not going in. I mean, that's pretty cut and dry there. If it's a private club, they would have to have like a charter or bylaws that would clearly lay out what the criteria for membership would be. And obviously it has to be legal criteria. But anybody willing and able to meet the criteria then would have to be allowed membership. But if you're not a member, you haven't joined the club, then you're not going in. So they would be exempt. It is important to note that I can always discriminate based on economic considerations. That would be a good one to remember. If I've got a property I'm trying to rent or rent out, and say the rent's $1,500 a month, and you can't afford $1,500, well then I don't have to rent to you, regardless of what protected class you may belong to. Because again, we can always discriminate based on economic considerations. Now, where you can get in trouble here is if you start changing the price. You tell one person the rent's X amount, and you tell another person the rent's a different amount. That's where you start. That's when you're gonna get yourself in trouble. So just know how much you're gonna charge, and that's what you better charge. But there's one protected class, even if you do meet one of these exempt criteria, there's one protected class that nobody can ever discriminate against for any reason. And that's race. Remember that. No one can ever discriminate against race for any reason. But why race? You got all the different protected classes, but here they've identified race as one that nobody can ever discriminate against. Why is that? Because of the Supreme Court decision of 1968, Jones v. Mayer. Remember, that's the decision that upheld the Civil Rights Act of 1866. And because of that decision, now under no circumstances can anyone discriminate based on race. So even if you meet one of these criteria and would be considered exempt from fair housing laws, nobody can ever discriminate based on race. All right? So there's your fair housing. Now we need to talk about another law called the Americans with Disabilities Act. And this might help you a little bit depending on how they ask questions on the exam, if you understand this. Obviously fair housing laws affect residential type properties. The Americans with Disabilities Act is more so commercial properties. So keep that in mind. If they're trying to ask you which law would cover whatever, are they talking residential or are they talking commercial here? Because if they're talking commercial, then we're dealing with the Americans with Disabilities Act, or the ADA, you hear it referred to. But in short, this law prohibits discrimination in the hiring or firing of individuals due to disabilities. We're going to talk about this a little bit. In fact, let me give you an example of what they're talking about here. Well, first of all, you see where it says the property owner may be required to make certain accommodations and or modifications, obviously to make facilities handicap accessible. But the point is, this act requires the property owner, if need be, to make necessary accommodations and or modifications for those that may have disabilities. In other words, you can't just open up a business somewhere, obviously open to the public, and say, all right, we're now open, all is welcome, unless you're in a wheelchair, sorry, there's no way for you to come in. Wrong answer. You're going to have to accommodate or make modifications necessary so that all can participate, regardless of the disability. Okay. It talks, again, this difference between fair housing and the ADA, which I kind of already touched on already. Fair housing dealing with residential, ADA is dealing with commercial. But before I go any further, let me make sure we understand what they're talking about, at least in terms of the accommodations. I know modifications, that's pretty self-explanatory. If you got to widen doorways, put in wheelchair ramps, that's what they're talking about with modifications. Well, what about accommodations? Say I was looking for an office manager or a secretary, somebody that basically sits at the desk at the front, greets people as they come in and so forth, answers the telephone. But let's say I was looking for a new office manager, and I know that job is 85, maybe 90% of that job is just answering the phone. Y'all get a lot of phone calls. Praise God. That's a good thing. But our phone rings constantly, all day long, and good part during the night for that matter. But anyway, a lot of that job consists of talking on the phone. Well, say I have someone applying for the job and they're deaf. They're legally deaf. They cannot hear. Does someone that's deaf typically do the best job answering telephones? Well, you might think, at least at first thought, no. However, they do have devices now that, apparently there's things you can put into the headset where someone deaf can actually hear and talk on the phone. They also make phones nowadays that with a screen on it that prints out what the other person's saying. So they might not hear them, but they can read what the person on the other end is saying. Well, again, so that might be an accommodation you can make. So instead of just telling someone because you're deaf you're not going to be able to do the job, if there's an accommodation available and you can make that accommodation, then you have to make that accommodation. You can't, otherwise that's discrimination. The other thing, and you'll see this in your book, in your material, but the ADA, the laws under ADA, applies to businesses, excuse me, with 15 or more employees. So if you have 15 or more employees, then you have to meet all the ADA requirements, and again, in terms of accommodations and for modifications. Just make sure you're aware of that. And again, it also states, when it comes to making these accommodations on whether you should or shouldn't, obviously the answer is you should always make accommodations unless it would cause an undue hardship on the business. Meaning it would be so expensive that I just can't do it. I just don't have the resources, the income, the money to be able to make this accommodation. But if you can do it, you better do it. Okay? All right. So now we switch gears again, and now we're talking about advertising in real estate. And obviously, what we're talking about here is, if you've listed a house for sale, obviously you want to get that out there. You want the public to know you got a house for sale. You're going to market it either through some kind of print ads or maybe social media, whatever. There's all kind of ways nowadays to market and advertise real estate. Well, two things you better be, and I promise you, probably both of these two things that we're getting ready to go over, you better know for test purposes. But before you can advertise a property for sale or rent, you better have a valid listing agreement in place between you and the owner of that property. I will tell you, in my market in particular, and you see this a lot, where maybe on a Facebook, somebody's Facebook page, they'll have a picture of a house that they're wanting to sell, but then you'll notice it will say, maybe somewhere in there in the ad, it'll say coming soon. Well, what does coming soon mean? Have you listed it or not? Where are you going to get it, where you can and will get in trouble eventually is, say today is Tuesday, and I know I'm going to be listing this property on Friday when me and the seller have time to get together and sign the paperwork and whatever. So I know on Friday I'm going to be listing it. So what a lot of agents will do, they'll go ahead and start marketing, advertising. House for sale coming soon. That's illegal. You cannot market or advertise in any manner any property for sale or rent if you do not already have it listed, under agreement to sell it. So you better have a written agreement to market that property before you start marketing. And I'll tell you, there could be some other issues as well. I'm not going to get into all of it because I don't want to get into the weeds, but what do you need to know here? You better have a valid listing agreement signed and in place before you start marketing or advertising any property. It also requires that when you do market or advertise, you must include in the ad the full name of whatever real estate company you're licensed with or the company you represent. That must be in every type of real estate ad or marketing. Okay? Even if you go on social media and say, hey, I just got my real estate license, to all my friends out there, if you're looking to buy a house, call me. That's advertising. And if you didn't put the full name of the company you were licensed with, then that's a license law violation. Okay? So those two things, make sure you have a written agreement to advertise if it's any property specifically you're advertising, or just any kind of marketing advertising in general. You better have the full name of the company you represent. And by the way, note it says the full name. You cannot use initials or acronyms. You can put that there, but the full name of the company better be there too. So if you got a long name company, that long name better be in that marketing or advertising. You better have it. Okay. Wholesaling. What is wholesaling? This is something investors do a lot. But the steps involved, you see here, they'll get a house under contract, and typically they'll put a house under contract, but in their mind they know they're not going to be buying this property. Rather, what they want to do is just get it tied up under contract, where obviously they could buy it. But during the time between they get it under contract and time of closing, they're going to be looking for another investor to hopefully just reassign this contract to them. For example, say you've got a property that would appraise for $200,000. That's what it's worth. But this investor somehow works out a deal with the seller to sell it for, say, $150,000. Well, obviously there's $50,000 in equity right there. So what they'll do is they'll try to find another investor to actually buy it, but maybe say, I'll I'll assign this contract over to you so you can buy it for, say, $180,000. Then that way you're getting, so the new investor is still getting $20,000 equity when they buy it. But if I was that initial investor, then I just made $30,000, right? Because I only have to pay the seller $30,000. Excuse me. I only have to pay the seller $150,000. The new investor owes me $180,000, so I get to keep the difference, which would be $30,000. But it's still a good deal for the second investor because they still have $20,000 equity in it, right? They could do it that way, or they could just say, for a certain fee, I'll assign the contract to you so that you could buy it. But anyway, y'all, that's what wholesaling is. Now, we'll tell you, again, this depending on the state you live in. You better know what the law says about wholesaling in your state. Obviously, when we get in the state-specific portion, we'll readdress this and talk about what the law is in your state. But right now, as we're just covering the national portion, just know a lot of states require you to be a licensed real estate agent to legally wholesale property. Because basically, you're selling real estate for a fee. That's what you're doing. And most states, a lot of states are going to require you to have a license to do that. Some states may not require you to have a license. But again, it's important that you know what your state laws are when it comes to wholesaling. But right here, I just want you to, just kind of like an introduction to what it is. And we'll talk about it some more in the state-specific portion. There's a practice that a lot of agents, we call love letters. And basically, so what's a love letter? Oftentimes, or it's not uncommon, let me put it that way, when a buyer gets ready to make an offer on a house, especially if you're in a big-time seller's market, where you got a lot of buyers interested in that property. You're not the only one. Probably going to be dealing with multiple offers. Well, it's not uncommon that a lot of times the buyer will attach what we would call a love letter to their offer. It's a letter to the seller, trying to persuade the seller to choose their offer. Sell it to me. Maybe I'll have something in there, I just absolutely love your house. I love how you've got it decorated. It's perfect for my family, and all this stuff, basically trying to play on the emotions of the seller, to try to get the seller to actually sell to them. And what the second bullet's saying here, when you do these love letters, this could cause the seller either consciously or unconsciously to discriminate. A lot of opinions when it comes to writing these love letters. I hear people say, no, there's nothing wrong with it. Some people say that don't do it. That doesn't belong in real estate. Look, and I'm not going to try to defend or take away from the use of love letters. But again, potentially, you better know what your state laws are when it comes to buyers writing these love letters to the seller. You may be in a state where the law is clearly states that that's a no-no. That's considered discrimination, and you're not going to do that. Other states may not address it and not see it as an issue. So again, right now, I just want you to know what it is. It's love letters, and just know, some states could have a problem with this for sure. All right. So we move on to the next topic of misrepresentation and fraud. Now, this is a big deal here. not only for test purposes, but y'all, this can get you in some hot water quickly for practical purposes. So, y'all, first of all, what's the difference between misrepresentation and fraud? Y'all, that's two different things. So what's the difference? In fact, let me just ask you, y'all, if you were to be sued in a courtroom, would you, not that either is going to make for a good day, but y'all, would you rather be guilty of misrepresentation or fraud? And I find most people always say, well, if I had to choose, I'd rather it be misrepresentation, and for good reason. So, y'all, what's the difference and why does it matter? Well, y'all, I will tell you, there's basically a one-word difference between misrepresentation and fraud. And hopefully you've already figured out what that one word is, but if you haven't, it's intent. Y'all, is it possible that when I'm talking to, say, a buyer, that I provide them with information that, y'all, at the time I provided that, I believed it, and I believed it was accurate. But find out later I was just wrong. I made a mistake. Y'all, then that's misrepresentation. Y'all, there was nothing, I didn't intentionally mislead them. When I provided them whatever information I provided, y'all, I sincerely believed it was accurate information. However, as it turns out, I was wrong. Y'all, that's misrepresentation. Y'all, fraud is when you intentionally mislead. Y'all, state things or provide information that you know is not accurate, but you're still providing it, basically trying to persuade somebody to do or not to do something. So obviously, y'all, misrepresentation would not make for a good day. You're still going to have some issues, and we're going to talk about that. But that's a whole lot better than being liable for fraud. Y'all, fraud is illegal. That means you have broken the law. Thank God, misrepresentation is not against the law. Y'all, we all make mistakes, right? That's what we're human. We make mistakes, and thank God, at least as of right now, it is not illegal to make a mistake. Now, you still may have to pay for that mistake, but at least it's not illegal. You haven't violated the law per se. But fraud, that's illegal. So here's what we need to understand about this. Y'all, if you ever wind up having to go to court, y'all, by the way, whoever would be suing you, do you think they're going to sue you? Are they going to sue you for misrepresentation, or are they going to sue you for fraud? And my guess is, y'all, they're going to shoot for the gusto. Y'all, they're going to sue you for fraud, because y'all, they'll be able to win a lot more in damages and all kind of stuff if they can prove fraud. Now, they may not be able to prove fraud. Maybe all they can prove is misrepresentation. But they're not going to start with the lower. Y'all, they're going to start with the higher. Y'all, they're going to try to get you for fraud, even though they may have to settle for misrepresentation. Well, how do you prove fraud? Well, what you're looking at here on the slide, as well as in your material, y'all, there are 6 elements. You see them all listed here, but there are 6 elements of fraud. And the person doing the suing, y'all, they would have to prove all 6 elements exist. All 6 of them to be liable and guilty of fraud. Y'all, if they can prove all 6 of them, it's going to be a really bad day. So what are these elements of fraud? Y'all, number one, first thing they have to prove is that a false representation was made. In other words, you provided some information we now know is not accurate. Y'all, that's the first thing they have to prove. Excuse me. The second thing they have to prove is that whatever it is you misrepresented, it was material to the transaction. In other words, it was a material fact. So how do they prove that the information you provided was a material fact? All they have to show is that that information you provided, they relied on that information in their decision-making process. So if I relied on what you told me in my decision-making, then that makes it a material fact, because I may have decided to do something else had you not told me or misrepresented something. So that's the first two. Now the third element, y'all, in my opinion, y'all, this is the biggie right here. This is the biggie. In fact, they even break this one out into two different parts. Y'all, the first part of this element says if it's made with knowledge of its falsity. Obviously, if they can prove that you knew it was not accurate and provided it anyway. Y'all, if they can prove that, as far as I'm concerned, you deserve anything you get. Y'all, that's just lying. You knew it was wrong and you said it or told it or provided it anyway. But look at the second part of it where it says, or reckless disregard as to whether it was true or false. What does that mean? Reckless disregard as to whether the information you provided was true or false. Y'all, all they have to prove, or all they have to show to prove reckless disregard is, y'all, they just got to show that the whatever information you provided, you obtained that information from some other source and you did not verify it yourself. You just grabbed information from wherever, assumed it's accurate, and then gave it to your client to make a huge financial decision based on information you don't know if it's accurate or not. You just grabbed it from some other source and you never verified that it was accurate. Y'all, that's something you got to be careful of right there. I could go on and give you quite a few examples of this, but the bottom line is, you have a legal obligation to validate any information you provide. If you provide that information, you have an obligation to make sure it's accurate. Okay? You just can't take information from another person or a website or some other place and just assume and hope it's accurate. If you provide the information, you better make sure it's accurate. You got an obligation to confirm all that information is accurate. Otherwise it's reckless disregard. You really didn't care if it was accurate or not. Anyway, that's the third element. The fourth element is that if you made, when it's made with the intent for the recipient to act or refrain from acting. In other words, if they can show that you provided the information knowing that this would be part of this decision-making process. The fifth element is if they relied on the information. And then lastly, whatever you misrepresented, it results in damage. But if they can prove all six of those things, you're going to be liable for fraud. And now you got a problem. One, it's going to be very expensive. I can't imagine you would not lose your license over it, but that's a serious issue if they can prove fraud. But again, they have to prove all six for you to be considered fraud. So going back to that third element, to me, it would be easy to kind of take this one out. First of all, you should never be lying. And again, if they can prove that first part of it, you're lying. You deserve whatever you get. But it's that second part, the reckless disregard. y'all verify information. Verify it. Y'all go look it up. Be careful with y'all, because as long as you can support that information and again, when I say support it, not, well, I got it from such and such a site and I thought that was reliable. No, y'all, you better verify. Y'all, you can't believe everything you see or hear online. Hopefully you know that by now. Y'all, even on YouTube, y'all, there are a lot of people on YouTube giving all kind of advice, and I highly recommend you don't adhere to much of that advice. Anyway, you have an obligation. So if you verify the information, you've eliminated any chance of fraud. However, well, what about the misrepresentation? They only, for you to be liable for misrepresentation, they only have to prove any one of these 6 elements. Like, for example, number 1, if they can show that you provided information, irregardless of whether you thought it's true or not, if we find out later it was not accurate, then you're going to be guilty of element number 1, and at the very least, you could and will be liable for misrepresentation. Right? So, but here's the good news. Remember, misrepresentation is not illegal. Doesn't mean you're not going to be liable for damages that you caused because of it. But at least you're not going to have the legal issues you would have if they could prove fraud. Now, if you created damages and all they can show is misrepresentation, hopefully that's what you'll have E&O insurance for. E&O stands for Errors and Omissions Insurance. This is just business insurance that hopefully you'll get. You should have it. But this insurance will cover you for any damages you created due to an innocent error or a mistake. That's what misrepresentation is. So if all they can prove is misrepresentation and you've got E&O insurance, then your insurance will cover the loss or damages created. But again, if they can prove fraud, again, fraud is illegal, you're not going to get out of that. In fact, I say not going to get out of it anyway. But with fraud, there is no insurance that will cover you for breaking the law. Okay? Fraud is illegal. Misrepresentation is not. So just be careful with those. And then the last thing here on this slide, obviously in your material as well, is a term called puffing. First of all, what is puffing? Puffing is when someone is stating an opinion that others might consider to be somewhat of an exaggeration. You're exaggerating reality. It's called puffing. Now, is puffing legal? Yes, and I remember that. They do like to ask that question, by the way. Puffing is legal, but I'm telling you right now, you better be very, very careful with your puffing here. Because there is a very thin line between puffing and lying. But if they're asking, is puffing okay or is it legal? Yes, it is. But is it possible that you might state something, in my opinion, such and such, that somebody else might say, I think you're exaggerating a little bit on that. I will tell you, it would be a good idea if you're going to puff, exaggerate something, which I will tell you, I think is a bad idea. Typically does not end well in business dealings. But if you're going to do it, you better have some way to support your opinion here. I wouldn't want it just to be totally up to somebody else. I'd want to be able to support my opinion on whatever it is I'm stating, even though others might consider it to be an exaggeration. Just be careful with the puffing, okay? Y'all, this is a little bit of a review, rehash, if you will, from I think it was all the way back in chapter 1. But y'all, when it comes to the broker in charge and the licensee's relationship, y'all remember when you're initially hired on with the company, you either have to be hired on as an employee or an independent contractor, right? You could be either one. But typically, I'd say probably 97, 98% of real estate agents, are hired on as independent contractors. Meaning you're going to get a 1099 at the end of the year. If you're an employee, you'd get a W-2. But you cannot be both. You have to be one or the other. And let me make sure we're clear here. I hear some people say, so you're saying I can't have a job as an employee somewhere else and be an independent contractor real estate agent? That's not what we're saying here. You cannot be paid as an independent contractor and an employee by the real estate company. So if I got a job at Walmart, and obviously I'm an employee there, but I'm an independent contractor with my real estate company, that's two different positions there. There's not a problem with that. But if the real estate company is paying you a salary and commission, that could be a problem there. Highly recommend you talk to an attorney and or an accountant or somebody, because that could get you, could cause you problems down the road. So you don't want to go down that road. To be an independent contractor, again, at least 90% or more of your income must come from the direct sale of real estate. And again, what they're talking about here, in fact, I'll just give you an example. Maybe this will help explain it some anyway. But and I've heard of people doing this, especially smaller real estate companies. But let's say I just started up my real estate company and I need somebody to sit in the office during business hours to answer the phone or whatever. And I really cannot afford to pay them very much. Again, because I'm just starting out. I'm trying to make a living myself, and I just don't have a whole lot of money to pay much of a salary to my secretary or office manager. So I might work out this deal with them. And just tell them, well, here's how much I will pay you in salary. But to complement that, because you do have your real estate license, when you sell a house, then obviously you can keep all the commission you make on the sale of the house. So in essence, I'm paying them as an employee and an independent contractor. First of all, you shouldn't be doing that, but what it's saying here, if you're going to allow them to get paid commissions, as an independent contractor, then it says that at least 90% of your income better come from the sale of real estate. So no more than 10% of your total income can be in salary. I hope that makes sense. I can pay up to 90%. Well, I have to pay at least 90% or more has to come from commission or direct sale of real estate. The most I can pay you in salary is 10%. All right. Moving on there. Actually, we're going to go ahead and stop and take another little quick quiz, and then we'll come back and knock out the rest of this practice of real estate.